Hello, my fabulous fellow seekers. I hope everyone is doing well. First off, I want to apologize for not responding to comments on maybe the last two videos. What I've been trying to do up until the end of school was at least be able to get a video out once a week, which I've, barely been able to do it. It is, you think the end of the year, everything's done. Well, in a way, really everything is done. The kids are done, the staff is done, but school isn't done. So we have to try to be creative in ways to make it go, till the end. So that has kind of held me up, but I always do like to go back and read the comments, even if I'm late in doing it, because it is important to me what you all have to say, and usually it's very funny or intuitive. So I do want to apologize for that. The good news is school is out, and I'm still like, it's very surreal when it ends. It's kind of weird because I get excited about it ending, but then there are certain students, many of them, maybe a few not so much, that I am really going to miss. And I'm used to seeing them every day, and then they're going to be going on to a new grade, and it's just like, so it's very bittersweet, but I shouldn't be saying anything. I should be enjoying my time, because before you know it, summer will be done and school will be back in session. So, but my hope is, and of course, if you don't want to hear all this, you can skip on to the rest of the Darrell trial that I'm covering. But I just like to communicate with you all because, this is the way I do it. And at some point, I probably will go live. I'm a little, me with my lack of tech knowledge, I'm sure I can do it. It's just a matter of, how and what. And a lot of people seem to enjoy it. They just turn it on and start talking. And I'm like, well, okay, what am I going to talk about? But I suppose we'll talk about trials and whatnot like everybody else. But yeah, that's probably going to come at some point. I'm not sure when. Maybe I'll figure it out this summer. Anyhow, we'll continue on with Darrell. I just wanted to throw those few things out there. And it is still, I got to tell you, I know I complain about the weather. I live in Florida, but it is still so hot and dry. I mean, I'm feeling sad for the birds because I have a little hose right by one of my windows that I can look out, and if I turn it on, there's a hose attached to it. A little bit of water, sprinkles out of it. And I noticed birds were going to it. They're so thirsty, and I'm like, oh my gosh! I used to have a bird bath, but it broke when the roofers put the roof on my roof. And so I feel like I need to go get some bird baths and put it in my front and backyard so the poor birds can drink. Because what do they do? My son says, well, yeah, if they're going to hang around your house. I'm like, well, we got lakes. Can't they go? No, they kind of just stay there. So I put a big bowl of water out last night because I'm kind of like that. I love animals. And it's just like, that's bad when the birds are searching for water. We have got to get some rain here in Florida. Now, I'll say that, and we'll probably get some dreadful hurricane, but as long as it brings rain and not death and devastation, that will be great. But having said that, the other thing I wanted to say too is that I have completed the Hannah Payne trial. Those of you all who have watched and followed it, it really was an interesting case. That concluded, and of course she was guilty on all counts, and she will spend life in prison with a possibility of parole. But if you watched it, you think, oh no, is that going to really be good for the family? Well, it is, because it's many years. I mean, by the time it would be possible for her to have parole, she'd probably be like 70. So let's face it, Miss Hannah's going to spend a long time in prison. So that concluded, and as promised, that some of you had showed interest in the Nikolai Mew trial, which was Very interesting. And I think I already put up an intro to that. And I'll start covering that, and of course continue to cover Darrell. And what else did I want to say? I just want to make sure I get everything out when I'm thinking about it. And of course, I believe that the Tracy Ferreter will be going to trial, I believe, in July. Well, we're in June now. It's already June next month, so I need to check on that. And of course, I'll keep you updated on Chad Dorman and Sarah Boone. But tell me all below what trials you've been watching. Because just because I may not cover trials, let me tell y'all, I watch a bunch. So I'd love to get your feedback on some of those. Well, if y'all have been watching the Chad Daybell trial, I mean, of course, Lori received life in prison last year, and Chad Daybell just got the DP. I've not watched every single thing like I've done Darrell. I've probably missed some with Darrell, but there are so many witnesses, but I've gotten the big gist of this thing. And for those of you who have watched it, horrific. And, you know, thinking that you can say this person's a zombie and, oh, their percentage. This is for those of you who have watched it. And all these people that died as a result of, and it's pretty much like the prosecutor said, it was about sex, greed, and money. How many times, think about how many cases it's all about the freaking insurance money. I mean, that's just, so many people have lost their lives. And that Chad Daybell, oh my God, I don't know what the heck Lori saw in him. I did not find that man attractive at all. I guess he had some sort of charisma. I'm not sure what it was, but he just showed no emotion. He didn't want to speak. He didn't want to do anything. I don't know if it's because he's like so sure he didn't do it, or he's so cocky and feels like because he's this alleged prophet who decides people's fate that he's just, you know. And Lori, crazy Lori, is in there as happy as if she had good sense, just seeming all cheerful and bubbly, and, you know, what nutcases. There's one. The other one, the ongoing one that is just turned, if y'all have watched it, into a dramatic circus is Sebastian Rogers. Oh my gosh. That has really touched my heart. You know, dealing with autism children in my class, and they are so, you have some that are not, that are low functioning, but you have some that are very high functioning, and it doesn't matter. I love them all. They all have something so unique about them that is just, and the way the parents, the step parents, it's almost become this big circus where it seems like people are losing track of finding this poor child, which by this time I'm worried that he's no longer with us. But that's another one. Let me know if you follow that. And that one's just, oh my goodness. And then the Madeline Soto case. I was going to cover that because that is so close to me. It's probably maybe about an hour drive from me. I am thinking of going to her memorial that they've set out for where they found her, because that's a horrific situation. If you've been following the Madeline Soto case, and her father is, or no, her stepfather, even though he has not been accused, nor the mom, but the mom has become very quiet. And there was, you know, definitely, you know, they have photographs of SA against her, and of course, he's, you know, he's the one who did it. But who did mom have a hand in it? I don't know. But that was another case I was thinking of following. Let me know if y'all have been following that. It's kind of on a standstill right now because the thing is, because of the fact with all the SA that he's done to poor little Madeline, I mean, years this has been going on. How do these mothers let these men into their lives? I don't know. But, things will probably get going on that. So let me know if that's something y'all are interested in. And what's the other one? Oh, goodness. I've only watched some of it, but it is sickening. Again, children, the treadmill dad case. Have y'all watched that one where this guy had custody of his young son? I think he was about 6, and he claimed he was too fat. And it shows video of him. How do these people think that people are not going to see them in his little gym in his apartment complex, forcing this child to go on the treadmill, and the child falling off, and man, putting him on there, and he said that the boy was too fat. Oh my gosh, that's horrible too. And I think I believe he was just found guilty of that. I'm trying to think. Oh yes, the Karen Reed trial. That's huge. That one is too mind-blowing and twisting for me to ever cover, but I've watched some of that as well. So I am out there watching, probably watching more than I should be. I should be putting out more videos, and I will. I just wanted to share those few things, kind of let you know what I'm watching. I love to know what you're watching right now and what really piques your interest. And I just pray all these people get justice. Okay, now I will go on with Darrell. Here we go. So they are still at the verdict watch point. And when we left, Judge Darrell was getting a bite to eat, and they were going to come back. And, that's when Darrell made all those creepy faces and was, oh my God, so sickening. All of that stuff. He wanted to take a shower. We don't know if he got to take a shower or not. Don't really care, honestly. But I think they're coming back now. So let's see what's going on with this now. Should be coming up here. Tried to get close to the place. Okay, come on. See, if I move it, then it'll be too far, because I thought I was pretty close. Let me make sure. These things are so touchy. Give it up just a little. Hopefully we'll get there. Again, sometimes my endings have been weird lately. I don't say anything at the end. I just end it. But I do always want to thank you all for watching, commenting, subscribing. I really appreciate it. And if you hit the like button, that's great. Doesn't cost a thing to do that. That helps a lot. And if you subscribe, if you've been watching and haven't subscribed, go ahead and subscribe. That doesn't cost anything either. I know all of us, me included, are kind of broke these days, so. Well, okay. Here we go. Yay.
So I wanted to, I need my court reporter. I'll wait for her.
I think I need to move my camera back a little bit.
Thank you. All right, it's 7:05. We're back on the record. I wanted to advise the parties that earlier today I received information from the clerk of court that she had received an email that the person sending the email had found a post on Justice for Darrell on Reddit, so it's a subreddit. I'm not familiar with how Reddit works, but
sorry guys, I'll get there.
And that the thread on the Justice for Darrell Reddit site was claiming to be a member of the jury pool. And I am going to provide the parties with the information that I was given this morning. It's a color copy of the attachment and the email that was sent. The email was received by the clerk of court at 9:10 a.m. Then my clerk received a notification at 9:30 a.m. that The clerk of court wanted to speak with me. You may recall this morning I stepped off the bench for a little bit of time. I read through the information that was provided to me, which was an email, and then the attachment, which is a color print off. Looks like the person took a screenshot, and that the anonymous post claimed to be a member of the jury on the case, and here are my thoughts on the trial and on this subreddit. And apparently, again, it's a subreddit called Justice for Darrell. All those, Justice, the number 4, and Darrell, all, no spaces. I then had contact with Captain Dussault, advised him that this should be investigated, and basically turned over the matter to law enforcement for a full investigation. At this point, or at that point, I made a determination based upon my review of the information that I would not stop what was happening in terms of the trial with the instructions to the jury and ultimately the closing arguments, and then turning the case over to the jury for deliberations. And of course, I am concerned about the integrity of these proceedings, and I will take whatever action that I deem appropriate once a full investigation is done. But at this point, there is no, I would say, credible information that this is in fact a member of the jury. But I will leave that for law enforcement to determine, and of course, if need be, at the conclusion of the case, when the jury reaches a verdict, I certainly will consider whether any questioning of the jurors at that point is warranted. So that's the information I wanted to provide. Again, copies of this information will be provided to the parties, and there is a full investigation underway by the Sheriff's Department. I have no further information about it at this time. I will not be the judge that will further be reviewing it in terms of any requests related to that investigation. I will simply be handling whether any requests as it relates to this case in particular. And I hope we have the copies for the...
Did you already hear his voice? You could hear his voice. Did you all see his face? His little tiny wheels and his little tiny head's turning. Now he's going to get all into this because, hey, why not? This could mean a mistrial. Let's face it. You know, he's going to go on and on about that. I mean, Darrell is pretty predictable. So, you know, he's going to go on about it. Now, I'm assuming that Judge Darrow, while she's taking it seriously, she probably feels pretty confident that it's okay, and no juror posted this thing on Reddit. But let's face it, Darrell's going to go on about it. So let's just go on and let him do it.
The parties. And provide those. Go ahead.
I'm making sure you use.
Go ahead.
First.
Oh, don't be polite now. You're going to prison.
All I can tell you, sir, is that there is apparently on the internet, on a site, or maybe it's an application, I'm not entirely sure, called Reddit. There's a subreddit that is entitled Justice for Darrell, and it was on that subreddit that someone wrote an anonymous post claiming to be one of the jurors. That, of course, would be a violation of the rules that I set up for the jurors, which is why I turned over the information to law enforcement so they could make a full and complete investigation.
For the record, I accept for value, return for value these documents.
Yeah.
I'm confused.
What's new?
At this point, sir, I'm providing the information. I trust that the parties will review it, and if a party believes that any request needs to be made of this court, then an appropriate request will be made. But at this point, I'm just advising the parties of the information that I have. And I will add this. I will, of course, it's important that the results of any investigation be turned over to the parties. I don't know how long that will take, but that is also my direction. That was really the only direction I gave to law enforcement, is that the results of the investigation that be turned over to the parties.
Was this? Oh, I'm sorry.
Go ahead.
Was this just found out about this morning?
Yes, the email that was sent to the clerk of court was received at 9:10 a.m. And then that email and the attachment, I'm aware of a second email that was sent to our clerk of court at 10:02 a.m. And I think when we stepped off the bench following the case being given to the jury, I was advised that other emails had been received throughout the court system, and I simply said, obviously that information needs to go to law enforcement. I haven't seen it, haven't reviewed it, but any person who works in the clerk of court's office who has received an email, that email about this topic will be forwarded to the sheriff's department. Their forensic unit is handling the investigation, to my understanding. Attorney Upper, did you have a question or something to state?
Yes, Your Honor, I just wanted to state for the record that I have also received similar emails at my office this afternoon. They were sent not to me directly, but to the district attorney's office website. And I only wanted to point out that in viewing the contents of the posting, well, first of all the emails refer to the exact same posting and the language is the exact same in all the postings. In viewing the contents of the posting, we question the veracity of the posting because it refers to things that, quite frankly, are not true. And also, upon reviewing it, Your Honor, we came to the conclusion that it does not exhibit any material prejudice against Darrell Brooks that may affect the veracity of any verdict that may be returned in this case. The posting is largely critical of the court and to some extent the prosecution, but the nature of the posting is actually in support of Mr. Brooks. That's why it's under a subreddit called Justice for Darrell. And I don't believe there's any reasonable reading of this post that would lead someone to believe that it suggests the juror harbors substantial or material prejudice against the defendant.
Thank you, I appreciate the additional record.
Can I say something, Your Honor?
Go ahead.
Oh yeah, why not?
Just briefly skimming through it. I do want to state for the record that I have no involvement with this. I'm really shocked like this even came to light.
Shocked that someone might like you? No, I don't know.
I will say just by skimming through it, these are definitely things that have been talked about in the court. So common sense would say that this came from someone that has either been in the court to hear what goes on in the court or a jury member. This is not.
Okay, I gotta stop there. I think I remember doing a piece on this, maybe a portion of it at one point, and I'm probably going to say the same thing I said on my other video, that it could be a juror or someone in the courtroom, but how about all of us who watched it on TV? So there's that. It could be anyone. I mean, everyone has watched this case among many others, so it could be anyone. So, I mean, nice try, Darrell, but I just don't think that's going to fly. That's just my piece.
No other way.
Well, actually, the proceedings are live streamed worldwide. Your Honor, available on YouTube worldwide.
Look at Attorney Basie giggling. I love it. I love these guys. Love them.
Well,
Whoa.
I mean, it's pretty obvious that this would come from somebody who's actually,
Obvious. I love his words.
I think it's pretty clear.
No, it's nothing.
Well, I'm leaving it in the hands of law enforcement to do a full complete investigation. Again, I take the integrity of this process incredibly seriously. And if there were to be a juror who violated the rules, I would take that very seriously, and I will not hesitate to take any action that I deem appropriate. At this time, it is simply being investigated. This was an anonymous post, and if either party believes any further action needs to take place as it relates to this particular jury, then I trust they'll file the appropriate request with the court. So with that, the courtroom, oh, go ahead, I'm sorry. Something else, Attorney Humphrey?
A different topic, Your Honor.
Oh,
if
sure,
possible.
go ahead.
While we're all together, I just wanted to address exhibits and what the court's procedure would be. We have no objection to any exhibits going back to the jury room if they are asked for, and precluding the requirement that we all assemble every time a note comes out asking for one exhibit. So as long as we're all here and we have some time, maybe we could discuss that.
I'm willing to discuss that. Do you have any position on that, sir?
Yeah, I would object from the standpoint that I would need to see any exhibit that's being asked about and the relevancy of that exhibit being asked for. I think that's only fair.
Exhibits that have been received of relevance objection would no longer be valid because the court has already ruled on the relevance and
That's
the
right.
admission of the exhibits. The issue is whether it goes back to the jury room. I'll give you for example. Sometimes in a trial there are medical records that need to be filed in their complete form under the statute, but really maybe only a portion of it would go back to the jury, or depending on why they were offered and whether there was any medical testimony regarding a diagnosis, for example, could impact that. Sometimes there's privacy issues with an exhibit, if there's a social security number for a witness or something like that. But generally speaking, the exhibits have been received, and the jurors can ask to view photographs, written documents. They can even ask to view the videos. The videos would need to be done one of two ways, either which requires everyone to assemble because we do have the technology to play them directly to the jury room, but that simultaneous with that is it would be played in here, so everyone would be seeing what's being played in the jury room at the same time. So that does require the parties to be in court, and that allows the jury to continue with their deliberations, talk about what they're seeing, etc.
So can the jury see in here now?
No, I'm talking about a video. We have the ability to
They're
play
watching
it
you, Darrell.
directly. There's a TV. I should have said that. Probably not. Why would you know there's a TV in the jury room? Right? So there's a TV monitor in the jury room that is connected to the technology in the courtroom. So whatever is playing here could be a still photograph, could be a document, could be a video. We can play in the jury room at the same time. But as far as other exhibits,
So it would be only the exhibits that's been
received.
So
Correct.
nothing new, nothing's gonna come out of the blue and be like, yo, yeah, we're gonna.
Only what's been received during the trial. If it would be helpful, I can have Madam Clerk give you the printout of the exhibit list that shows everything that's been received, if you would like.
That's about like 7,500.
There's a lot of exhibits,
That's
but
a lot of exhibits.
but I'm
Oh, he's
willing
being
to
all
have her print it
jokey
off if you
and
would like it.
jovial. Stop
I
it.
think it'd be helpful just in case. I'm guessing at some point that would come into play.
Right. For example, they may come back and say, we'd like to see Exhibit 15, which is the map, the large map of the parade route, okay? They might want to see the other map. Maybe they want to look at a video. There's a lot of exhibits, so I'm not going to speculate what they want. Sometimes they write notes to us and say they literally list out all the exhibits that they want. Other times they'll say, can we have all the exhibits? So sometimes parties do stipulate, that's what the state, I think, is trying to get at. So do you have a position on that? If the jury requests an exhibit, do you want the court to rule on it individually, or do you agree that if they request an exhibit, it can be released to them?
A rule on it.
Yeah, he's
All
not
right,
going to
fair
agree to
enough.
anything.
Anything else, Attorney Alper?
Yes, we had discussed yesterday, and I'm not trying to get too far ahead of myself here, but what was the time limit that the court wanted to work off of for giving notice to the parties when the verdict is available?
30 to 60 minutes.
Okay. Thank you.
So that will depend on when it is, if it's
Yep.
late in the evening versus during the day. And you might be wondering, how late will I let
I don't know what happened there.
that we're done for the evening?
There we
They'll
go.
come back in. I'll read them the instruction about they obviously can't deliberate when they're not here, so I'll read through that instruction to them that you can't deliberate. And they would go again where they are being sequestered, and then we would reassemble tomorrow morning if that's what is needed.
Okay. Thank you.
You're welcome. Anything else from you, sir?
Did you talk to the deputies or
I did. Thank you for that reminder. The jail has asked that I follow the standard operating procedure, which is to have you in central holding and not up at your cell. But if need be, I'm willing to order that they give you a shower later, if that's helpful, whether it be tonight or tomorrow morning, okay? So even though you're going to stay close by, I'll make sure, I'll work with the jail to make sure that you're given that opportunity after we're done for the night, okay?
Yeah, at least let me take a shower.
Yeah.
So I've been,
And I would have
there
to-
is a question that will be coming out shortly, so don't go anywhere.
Don't choke me, Judge.
What?
I said, don't choke me.
Choke you?
Yeah, because you know what I'm about to say.
What are you about to say?
Subject matter jurisdiction.
Oh, for the love.
You knew I was about to say that.
Sir, I'm not going to address it. I already have.
The jig
All
is
right.
up.
There are requests for 3 exhibit. Is that his number? Yeah, he signed it, but I do.
Oh.
I meant to tell them that. It's a signature. I need to know the number to tell the parties who the 4th person is, because I'm not going to say the name on the record. They have a request for 3 exhibits, 15, 5, and 55. Number 11 is the 4th person.
You said 15, 5, and
55. So I can pull.
I was gonna say I don't know. I know 15.
15's the map.
15 is the map, yeah.
Any objection to the map, sir?
Yeah. I want you to rule on everything.
Well, I was going to go one by one. So I'll start with exhibit 15, which is the map. What's your position on that, sir?
My position is at this point, what is the relevancy of the map? I
Yeah.
think it's been seen a million times.
They're deliberating
I know
your
by heart
fate.
now. That's probably the only.
Well, that's good for you. But they're deliberating your fate right now. Well, that's probably why he doesn't want them to see it, because it just brings them closer to his guilty verdict. But, he's going to, protest to everyone, so we'll just let him. The judge is going to go ahead and, let him go through the motions.
When I know by heart.
Well, what's the state's position?
Yes, we absolutely, there's no reason not to send that back there, Your Honor. There's 76 counts that they need to work through, and to assist them in identifying which victim is which and which group they were with and where they were on the road, absolutely, there's no reason to hide that from them. It's helpful to them in their deliberation.
All right, I will send Exhibit 15 back to the jury room. It is an exhibit, and there really is no reason not to send it back that has been identified by the parties. All right, the next exhibit is Exhibit 5. That is the photograph of Eric Patterson.
Ooh,
Oh, I definitely object to that.
I bet you do.
Seeing as how there was supposedly 2 incidents, one of which didn't even happen, which the prosecution sent paperwork to acknowledge that it never happened. So I don't even. It's too dicey with that. What incident would 5 be referring to? One of which
The
never
battery
happened,
count.
and then one. I don't even know what I'm looking at if I look at 5.
Now there you go.
What's the state's position on 5?
Again, Judge, there's no legal basis to exclude that from the jury. There's nothing prejudicial. It's a single photograph. I should say overly prejudicial. It's a single photograph of a single person showing the injuries that are alleged to be associated with count 77. It's directly relevant to their deliberations.
There is no count 77.
Count 76. You are correct. It is count 76, not 77.
See why I'm confused?
Yeah, you'll be all right. You know, I know we talked about this before, but at first I was thinking, and it could still be the case, that DA Opera was purposely saying that so Darrell could, get him in a dither and all that kind of stuff. But maybe she really did say it on accident, but it does kind of get him going, which is kind of funny.
Well, there is an amended information, and I clearly instructed the jury at 76 counts. Be that as it may, I'll find that it is proper for Exhibit 5 to go back to the jury, and that will be sent to them. Now, Exhibit 55 is a video. How long is that video?
About 15 seconds.
So my inclination, and I'll hear from the parties first, and then I'll give you my inclination. So any objection to playing for the jury Exhibit 55?
What exactly is in Exhibit 55? I don't.
It's a video from Curry Insurance facing eastbound showing the grannies being struck.
Ooh.
We could put it up if you want to preview it, Your Honor.
Go ahead.
And we are requesting that it be viewed by the jury in their deliberation room.
What I can tell you, if I do allow it, since I would have to we'll verify that the technology is working, and then I would play it for them twice through. And we would watch it at the same time as they're viewing it. Theirs would just be in the jury room. But I'll preview it for Mr. Brooks so he can see it first. Well, the state will preview it for me. All right, your response, sir?
Yeah, I object to it. Keep this in order. I guess my objection would be it would be hard to say why the jury would request it.
Because it's evidence.
I'll just let you rule on it. I don't particularly. There's so many videos that's kind of like the same video anyway.
Well, Exhibit 55 was received by the court. It's relevant to the charges in this case, and I will show it to the jury. I will work with Teresa and then the jury bailiff to ensure that the technology is working when it's up and running. I will play that for them twice through. This is what I have proposed to write on the note back to the jury as it relates to all three. Exhibits 15 and 5 are attached. Exhibit 55 will be played for the jury 2 times, hyphen the clip is 15 seconds. And then I will initial that and date it.
Any reason why we need to be played twice?
And I just would note that the jury foreperson wrote yesterday's date. It is the 25th. My date will be indicated. Obviously, they didn't get the case until today, so it's just a Scrivener's error on their part, putting the 24th versus the 25th. They don't have their technology with them, so I can't really fault them for that. All right.
Any reason why it needs to be played twice?
That's my practice, at least on short video clips.
So what about if they request for a long video?
Then I'll make a determination then.
Don't worry, she has an answer for all your questions.
I find that since we have the new technology, it's easier just to do that and play it twice than to bring them out and for them to say stop and then can you go back and can we watch it again, because that's my experience. So I'm really trying to avoid that.
Yep, that's
so
right.
We'll stay out here and then Jen is the one. We'll work to, they'll have to pause their deliberations so we can interrupt them and give them the exhibits and then make sure the technology is working. So if the state wants to have that ready to go.
I set for value and return for value these documents, Your Honor.
Thank you.
Yeah, thank you.
Do you have, you know how to do that, right? I've done that before. It's one button.
Is Jen ready for me to turn it on?
Is there audio with this, or is it just video?
Just video.
Okay, thank you.
Like somebody else said, his head does go back and forth like a typewriter when he reads. Yeah, how hard it must be to watch those videos, like the grannies getting struck. Everyone else. Little Jackson. I think one person, that guy right there, did all of that. To use his word, is mind-boggling.
Is it on? All right, the video was played twice. We'll wait and see if they have any other questions.
Your Honor.
Oh boy, here we go.
About this Reddit.
Oh, here we go.
Reddit.
That's my understanding.
Here we go.
This particular person is who the email was sent from, the person at the top of the page?
Do you have the email that has the 9:10 a.m.? That's my understanding, yes.
Were they identified to have any connection with the trial in any way?
I'm leaving the entire investigation in the hands of the Sheriff's Department. I can't answer that. I'm sure they're looking into it though, because that's a good question.
You know Darrell's going to chew on that for a while because he's got to think up some way to stop the process. Anything. Look at his ridiculous expressions. He put his mask back on. Which is funny because I wonder if, like, when the jury returns, will he pull it off again? Well, you know he's going to have another question.
Somebody still wanting to know if the 50%, but they want to talk section.
Yeah, they'll have to submit that. All right, I'm going to step off. Obviously, the courtroom remains open.
Look at his
And
face.
we'll let you know if there are
What?
any additional questions.
Look at his face. It's almost like, what do you mean, step off? You have the audacity to step off? Wait a minute, I'm still here. Why are you stepping off? Is he going to let her go without saying something? Look at his expression. I doubt it. Let's see.
Subject matter jurisdiction, Your Honor.
I decline to address that, sir.
Will we be addressing it for the record?
I wouldn't go too far because
Oh, ridiculous. Ridiculous. You need to close that chapter of the subject matter jurisdiction.
Mr. Brooks?
Well, what's the significance of seeing it as different speeds? Was that in the question?
They just said, can we see Exhibit 55 at 40% speed? Obviously, I don't recall specifically if this video was shown at a reduced speed, but many of the videos were shown at reduced speed. During the trial, that was allowed. I think it's proper to also show a video clip to the jurors if they request it at reduced speed. So I'll grant the request.
What would be the significance?
Probably to
The
see it better.
significance is the jury's requesting it, sir.
Thank you.
I'm saying at that speed.
That's their request. I can't tell you the significance for them. I don't want to speculate. But I think it's proper given the technology that we have available and what was done during the trial. So I will allow it.
So why even ask me if I have a position?
Because that's what I'm required to do, sir.
But you're not required to address subject matter jurisdiction.
Oh, for the
which has
love.
been proven for the record.
Oh, shut up.
Not allowed to answer any questions I ask.
Oh, poor you.
Mr. Brooks, I'm not going to relitigate your case right now.
I mean,
And I've made my decision on subject matter jurisdiction, so your request that I address it once again is denied.
of course it's denied. Of course.
Shut up,
Because you can't
Darrell.
prove
Oh, my
it on
God.
record. Come on now. Has yet to be proven. has to be proven at some point. Or do I gotta go through the song and dance to get it proved?
No, she's already done it.
Are you ready with the 40%? Was they are?
Jury's ready?
Are we doing it once or twice, Judge?
Just once.
That's 40% speed?
Just shut up.
Yay, nay.
Nobody really wants to answer your questions right now.
The video clip is now ended. Would the state just confirm the speed at which it was just played?
Yes, 40%, Your Honor.
Thank you.
There you go. Happy now, Darrell?
Right. Let me know if there's another question. The court's going to step off. Obviously, will remain open.
Yeah. He's like, wait, what? I don't get to step off? Oh my goodness.
At 7:47, the foreperson provided a question through the bailiff. We request exhibits 3 and 4. Exhibits 3 and 4 are videos. They are the videos from White Rock, I believe, elementary school. Door 1 and door 2.
Mm-hmm.
Yes, correct.
How long are each?
Just 1 second.
Those are the ones with Darrell and
Exhibits.
Erica. And
3 is 4 minutes and 14 seconds.
the other two, I believe.
And exhibit 4
6 minutes or something?
is 6 minutes and 58 seconds.
Corey and Nick.
7 minutes.
Okay.
Shut up, Darrell. Nobody really cares. What do you have to say?
My inclination would be to play each one time, since they're a little bit longer, and play them one after the other. From the state?
Agreed.
From the defense?
Objection.
Noted for the record. Any specific reason, sir?
The significance of both videos.
Their evidence, sir?
Good.
And the jury's requested to look at them. So I will be playing them for them. We'll do exhibit 3 first, and then exhibit 4 shortly thereafter.
Will you be addressing subject matter
Oh
jurisdiction?
my
on the record?
gosh, shut up. You just can't be quiet, can you?
No, I will not.
She shut that door.
Judicial determination, Your Honor.
Can you say the story?
I can't. Oh, you're not asking me.
Is that a tacit agreement, Your Honor?
Shut up.
Right, they are ready.
The arrow in the middle of it.
Oh, we can get rid of that clear annotation.
Is that a tacit agreement, Your Honor?
Go ahead and play exhibit 3 in its entirety. Here you go. You got that. Yeah, exactly. You can stop that one. They're asking it to be stopped. Any objection from the state?
Nope.
From the defense?
No.
Okay.
Okay, so I was recording.
All right. Switch to exhibit 4. They're finished with that. Any objection to stopping that video?
No.
All right, Mr. Brooks.
No.
All right, it'll be stopped.
Judge, for the record, this one was stopped at 1:38. Do you know what time we stopped it on exhibit 3?
35 seconds, I think.
Thank you.
Sure.
Thank you, Madam Clerk. Okay, I would think you might want to stay close by.
Was that a good way to reach the state?
I'm not sure
Yeah.
it did.
Advised that the jury would like to be done for the evening and come back tomorrow. So I said they should assemble. We'll get the alternates because they're sequestered.
Okay. Sounds like they're gonna sleep on it. Well, they probably already know what they're gonna do. Let's face it. It's pretty clear cut to me. I mean, it should be to
Like
most.
to break for the day. I need to basically tell them that because they're breaking for the day, they should not continue their deliberations while sequestered until they're back in the jury room. So I'll read a modified kind of version of instruction 50. We are in the record.
Subject matter jurisdiction.
Oh, shut up.
I decline to address that further, sir.
Will it be proven for the record?
Sir, my earlier decision, I stand behind it, my written decision.
Your written decision that's not based in any law or fact?
Hold on.
You just delay it the best you can. Just shut up, Darrell. Please don't say anything else, Darrell. Just be quiet. What if he's going to take his mask off when they come back in?
Can you see them come in? I think they're assembling the other alternates. They're in a different place. So you have to get every.
Yes, we do need them to give the instructions.
Yes.
I thought it was 2 people that got excused from the jury.
3. There were 15.
No, I'm saying I thought it was 2 from the 16.
No, only 1.
Well, you did say 2. You said one had got excused before, and then another one was getting excused.
No, I only excused 1.
Darrell, shut
We've
up.
had 15 since the first juror was excused.
So what happened to that second one that had the COVID scare? I don't know what that.
Mr. Brooks, I addressed all of that on the record. I'm not rehashing that now.
Thank you. She's exhausted.
No need to get in your feelings. It's been a long day. I'm tired too.
Nobody cares.
I would agree. But I'm just letting you know I'm not going to rehash that stuff.
I just thought you said 2. You said 2 on the record.
Just shut up, Darrell. Nobody cares.
All right.
Look at there. He's taking off. Now he's going to look all... Look how he looks. He looks ridiculous. He's trying to look all innocent and a bit pious, really. Look at that. Oh my God, he looks like a fool. What does he think he's going to do to change their minds at this point? After all they've seen, all his nonsense they've heard. No.
Thank you, everyone. Please be seated. The record to reflect, I have the 12 jurors who have been deliberating, plus the 3 alternates who were sequestered in a different jury room. I want to give you kind of a modified instruction from the one that you've heard many, many times throughout this trial. Of course, for the 12 who have already started to deliberate, do not deliberate unless you're in the jury deliberation room. And that will mean from when you are discharged here tonight until you come back tomorrow in the jury deliberation room. Do not discuss this case among yourselves or with anyone else until you are deliberating in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging or social networking sites to send or receive any information about this case or your experience as a juror. I realize you are sequestered. We've taken away all of those things, but I'm just going to keep reading through this. If you come in contact with the parties, lawyers, interpreters, or witnesses, do not speak with them. For their part, the parties, lawyers, interpreters, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene either in person or by any electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device including personal wearable electronics, applications, or tools with communication capabilities, to share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so despite your telling them not to, you should report that to me. I know you're not going home. You're going to another location, but do not discuss this case among yourselves with any other juror until you are back in the jury deliberation room tomorrow. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After this trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at the trial. With that, you are all excused for the
Oh my
evening. We'll see you
gosh.
back here
What a
tomorrow.
lame-looking
at
smile.
8:30 a.m. All rise for the jury.
This is my last chance to impress them. Not. Looks like you can't wait to say something, but maybe not.
All right, thank you, everyone. We are in recess. We'll see everyone tomorrow morning at 8:30, 8:30 a.m. I trust that the jail will give you a shower, so whether that's tonight or tomorrow morning before you come back to court.
Yes.
But I will order that.
Good morning. That's 8:30.
8:30.
I'm not getting up there early. It's gotta be tonight type thing. Oh,
That's when we start court every morning, sir.
no, it haven't been.
Oh my gosh. Isn't he sickening? Talking about his fate and complaining about what time he has to get up. He just, I don't know. There's something wrong with that man. Okay, we should be into the next morning. Hopefully, for everyone's sake, Darrell got his damn shower. Let's see what's going on now.
We are back on the record in State versus Brooks. May I have the appearances, please?
Morning, Your Honor. Sue Opper, Leslie Bates, Act Hotel Officer in State Wisconsin.
Thank you. And sir, for your appearance this morning?
Just 1 second, I was certainly not thinking.
Can you say your damn name? What are you fumbling through?
I'm not sure if I even have it. I apologize for that,
It's all right.
man.
When you're ready.
I'm here as third-party intervener in that matter, appearing as authorized representative for my client. I'll set for value in return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and make a reservation of all of my constitutional rights, mostly the First, the Sixth, and the 14th Amendments.
Lord have
Thank
mercy.
you. The record to reflect that the individual known to this court as Darrell Brooks is present in custody in person. He is wearing his jail attire this morning. I do want to make a record that at 8:46 p.m. yesterday, I did swear in 2 additional sheriff's deputies who would be working with our jurors through the overnight or third shift hours. I did administer the same oath that was administered to all the other bailiffs yesterday evening. Then, of course, we are open, and the jurors are here, and they will be instructed to start their deliberations. The only other thing I would put on the record is I have received information regarding the Reddit post, that there was a subsequent post from that website indicating that it was a prank. And so I don't know to what extent the Sheriff's Department is looking into that as well, but it's my understanding, based on news reports, that that entire post or site was taken down. Not the site of Reddit, but it's no longer, I believe, viewable. But there was that additional information regarding that, at least from the administrator, I believe, of that post. So I just wanted to put that on the record. And if and when, or I should say when, the investigation is completed, I will assure the parties that you will be provided with that information. So go ahead.
Here we
So it's
go.
being called a prank.
Per the Reddit post itself, yes.
So we don't have any idea if that's a fact, though, right?
You're correct. I'm just putting on the record the additional information that's been reported on. And then again, once the Sheriff's Department concludes their investigation, it will be turned over to the parties. So at this point, until there's a question or a verdict, the courtroom will remain open. I'm going to be working in my office on other things, and will be available, of course, if there are any questions or if a verdict is reached. And so notify the parties.
Sure.
Yes.
Oh, go ahead.
No,
Go ahead.
Go ahead, go ahead. Let the Reddit thing go.
I'm still very concerned about this
Oh,
whole
we know you are. Bless your heart.
Reddit thing. After having the chance to fully read it and look at some of the language that's in it. It's very concerning.
Yeah, we're not
That's
going
why
to
there's an investigation, sir. It's anytime there's an allegation that the integrity of this judicial process has been compromised, especially with a juror, I take that incredibly seriously, which is why I turned it over to the Sheriff's Department.
I would like Your Honor to, if it pleases the court, if it pleases Your Honor, I would like to look at some alternatives.
Yeah. You mean like
bring up the
mistrial?
in regards to the language. I also want to state that for the record, this did not come about from the prosecution side, from the defensive side, and certainly not from Your Honor's side. This is something that just pretty much sprang up. A lot of my concern, though, just not from just the language in the actual post, but I was kind of concerned that I was the last one to learn of this information that had been known.
Oh, glory.
I wasn't aware of it until after 6:30 last night, or around that time, because I don't want to misquote the record, but somewhere around that time.
Shortly after 7.
Oh, so it was after. I didn't know. I thought it was. I knew it was after 6:30, but I didn't want to incorrectly state the record. Your
I can
Honor.
address that for you right now if you would like.
Yeah. If it pleases you, Your Honor, I would like to request some alternatives to this issue.
What's your specific request?
My specific request would be to look into a mistrial
Yeah.
and also any alternatives
Mistrial, he says. No, there's nothing.
along those lines, short of that, or along those lines, or a mistrial.
No,
I was
no,
looking
no.
at some, obviously, yesterday was very, very long for everybody.
Mm-hmm.
And as you know, because of my status here in the jail, I'm allowed to have law library time up until a certain point of the evening, and then I have to shut it down per jail policy. So I was able to find a few different things that I wanted to bring to Your Honor's attention, if I may.
Go ahead.
Go ahead.
One being United States versus Perez, 22 U.S. 579, and that specifically, I think, is referenced because that one is pretty old in itself, but it's referenced in a lot of the other case laws that I actually found. I think, and I could be, if I'm interpreting this incorrectly, I apologize. They kind of use that as kind of like the benchmark for what they refer to as manifest necessity. That's kind of like one of the leading cases that each one references in regards to issues similar to things like this when it comes into play. And it specifically points to trial judge's discretion. And I think that's kind of like the leading one. Also, I looked at Brown versus Rushton, 572 F.3D 198, which speaks to language is basically, it speaks to the same thing. It speaks about manifest necessity. It speaks about if there's an issue of exculpatory evidence, things of that nature.
Lord.
Also, United States versus Bates. That's BATES. 917 F2D 388. And that speaks of potential for an impartial verdict. Specifically, it says along the lines of impartial verdict, if an impartial verdict can be reached, or if a verdict of conviction could be reached but would have to be reversed on appeal due to an obvious procedural error in the trial. That's one of the main issues that speaks to. I also looked at Arizona versus Washington, 434 U.S. 497, and that speaks to what I was stating before. It says neither party in a case has a right to have his case decided by a jury which may be tainted by bias, and I say that because it certainly wasn't anything dealing with the prosecution. They had nothing to do with this. The defense had nothing to do with this, and certainly you, Your Honor, had nothing to do with this. But just for the concern factor, the language, it's pretty clear that this
It's not clear or obvious, as he always
is
says.
not directly came from a juror who sits on this panel. It came from someone who sits in this courtroom every single day. The
No.
language, it directed towards you, Your Honor, directed towards having clear bias towards the defense. Some of the things that they quoted of having knowledge of is extremely concerning. Extremely concerning.
Yeah.
And
Yeah. I'd be more extremely
going back
concerned
to
about
some of
your
these
fate.
case laws that I cited, it talks about something to the effect of you know, the ends of public justice. But I think that is leaning more so towards the judge's discretion, I would say, at least from how I was interpreting it. Obviously, I'm not educated in a lot of the laws in itself, but how I was interpreting it, this is definitely a concerning issue. It's definitely something that I would request Your Honor to take a long look at. Look at some options, look at some alternatives. Then those case laws I cited talks specifically about that, options that you, Your Honor, can look at and use your discretion to see if it's appropriate in any way. But I'm extremely concerned about this. If anything, for cautionary reasons, I believe, Your Honor, that you definitely should take a look at everything I'm saying here in these case laws and
Spit it out.
What's the request though that you're making?
Yeah, really.
Based
Let's get to
upon
that.
the case law that you cite. I heard in there mistrial, but I want to make sure I understand your request for relief and what it is.
You said request for
Relief.
relief.
Like, what are you asking me to do based upon the information that the limited information we have about the Reddit post and this trial?
I guess my request would be, because of the concern of this, to look at a mistrial,
Good luck.
or at the very least a discharge of the jury at this time.
Sure,
So
yeah. Time waster.
this can be resolved. This is alarming. To say
You don't
the least.
you don't even sound alarmed when you're saying it.
This
No one's alarmed.
post, and I don't know what Reddit is, to be honest. I've never heard of it or used it, so I don't know the extent of. It's almost like this could be like a snowball type of thing. It can start with something that's this small, and then it can snowball out of control into something totally different. I don't know the extent of this website.
I know way back there was talk that his one supporter, Jay Prince for president, may have written it, but I don't think that was ever proved. But that was one theory somebody had way back. But nah, it's nothing. But hey, you gotta give him an A for effort.
I don't know who. Well, I think the name of the person who sent the who alerted the clerk, of course, to this post. I think his name is in the email.
Oh,
But then that
please.
even begs the question of
Oh my God,
how
I can't-
did this person come across this site? What is their significance to this? What is their role in this? It's just so many questions, and
Not really.
I mean, clearly this points at the court's integrity. It points at your integrity, Your Honor. It's alarming.
You
It's
were not.
very alarming.
You were not
And
alarmed.
if there's a chance that there
You
can
sound
be
alarmed.
hidden bias in this jury, it needs to be addressed now rather than later.
Well, of course it does. Bless your heart. Okay, could you stop talking now?
This is very concerning.
Mm-hmm.
Well, thank you for bringing up your concerns. Let me turn to the state if they want to respond, and then see what other issues they want to cover this morning.
Judge, the original post was on a subreddit thread called Justice for Darrell. That's the copy that the defendant has in front of him. That post was edited last night, claiming that it was a prank from the start, and that the original poster didn't think it would get that far out of hand. The way that Reddit works, the only person who can modify the content of the original post is the original poster, and because the jurors have no access to any electronic devices,
There you
I
go.
think it's safe to say that our 12 jurors back there are not the original poster. So I
There
think
you
that
go.
puts that issue pretty
Very
much
simple.
to bed. It's still obviously under investigation because the court takes it so seriously, but there really is no actionable or any real reason why we should doubt the jury's being unbiased in this case.
Very simple.
I object to that on the grounds, Your Honor, that,
Of course you do.
like you just said, it's an investigation going on. And if there's
Yeah,
an
but
event,
he pointed out, Attorney Zach pointed out that it was edited the night prior, and the jury had no access to any kind of device. So there you go. But he's gonna still blather on about it.
investigation, then that clearly says that something is amiss.
Yeah, you're a miss. I'll tell you that much. You're the one who's a miss.
We have 15. We have 15 jurors. There's still too many questions that we don't know.
That's
Too
okay.
many. I don't think anything's put to bed because we don't know. It's unfair to say that the issue is put to bed when there's still so many questions left out there.
Not really.
I'm sure you reviewed it yourself, Your Honor.
Of course you
see
did.
the language in this, whatever this thread. I don't know. I don't know what this is. It's clearly a post from somebody who has intimate knowledge of the trial and what's going on in the trial. I don't think. I mean, common sense would tell you
No,
that this
you
is
don't have that.
someone who's very close to the case. Whether they were intended to be funny, whether they were intended to try to prank the court or anything like that.
Let it go,
We don't
Darrell.
know. That could be anybody's guess. The language in this, the way that it's formatted, they lay out 4 specific points of what they think they point to certain language in the case. They make references to saying when we were in the room, they got certain feelings from when they specifically referred to themselves and a group. That would be we, plural.
Could you do your plural and your singulars?
They say, and I have to admit, I am biased against the defendant for the horrible acts he did. And they attack you, Your Honor. They clearly attack you. This is if this is someone's idea of fun, is anybody's guess, but I don't believe that it is, clearly by the way it's formatted and by the language that is in it. This is clearly someone with intimate knowledge of the case and what's going on.
Clearly, obviously. Those are his favorite words.
There's no other way. There's
Among
no
many
other way
others.
to interpret this.
Oh, yeah,
You
there
can
is.
tell by what they're laying out in the language that they're speaking with.
I think Attorney Zach laid it out beautifully in just a few words. That's what I love. Man, there's people who are a person of a few words, a person of many words. Darrell is a man of too many damn words.
This is clearly someone close to the case, and
Yeah.
because of that, it still has to be. I'm informed in the investigation, but there's still too many questions left in the air just from this. How can we say anything's put to bed when there's still an investigation? For all we know, what if this turns up that it was someone on the jury, or what?
It won't
what
be.
if it turns out that more people are involved in it than just whoever this anonymous person was who left the post? It's too many questions and it's too concerning. What if something like this springs up again at the last minute? We've been going through the trial now for
Oh, Lordy.
basically 3 weeks, the better part of 3 weeks,
Yes.
and even in court days leading up to the trial, we've never had anything like this happen. Nothing like this has been brought to your attention. Nothing like this has been brought before the court's attention. This just came out of the blue, and now all of a sudden it's being labeled a prank. Is that because they were found out? I mean, it begs so many questions. It's too uncertain. It's too concerning, and it's too alarming. It's too alarming
There's
to
the
just
word.
overlook and say, "Oh well, we'll just set it to the side and let them." No, this
Elizabeth,
there has to
no.
be some type of alternative.
Like he makes, yeah, alternative like mistrial. No. It's not alarming. What you did to all those people was very alarming and disgusting, and I can't even think of enough words. Abysmal to even, to describe it. So no, this is not alarming.
Is something has to be done.
Oh yes, it does.
Something.
Yeah, we need to go on and get you.
Trial, if that's discharging a jury, if that's some other type of alternatives that can be looked
Sure.
at, I'm sure
No.
that these case law speaks to.
Look at them. They're like, he's stalled enough. Now, they may not be saying anything. I mean, they're professionals, but look, I try to be professional, but sometimes it's hard not to be. They're going, can you believe this? Do they look alarmed about it? Okay, go on, Darrell.
Other options that could come into play, they deserve to at least be looked at.
I think,
if anything,
didn't you already say that the police was taking care of that? Blah, 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 blah. I do believe that's what she said. So, I guess she's going to let him go on because, good God, this is, oh, okay, here we go.
the integrity of the trial?
Oh, yeah.
I find it very hard to believe that this close to the trial being over, now all of a sudden these issues are being raised. So this is obviously not a prank, and it's obvious that this is someone with intimate knowledge. It's very clear to me.
Well, I'm glad it's clear to you because,
Well, let me address your concerns, sir. I cannot make conclusions at this point about whether this is legitimate or a prank. What I know is as follows. I received the information about the subreddit post at approximately 9:30, 9:40 yesterday morning. I alone made the decision to withhold advising the parties because of where we were at in the trial, because there was nothing in that post. It was an anonymous post that would lend credibility to that it was in fact one of these jurors. But out of an abundance of caution, I referred it to law enforcement because it is very serious if the integrity of these proceedings were to be put at issue by a juror. I'd remind you though, every single day these jurors were read the bulk of jury instruction 50. They all took an oath, and I have no reason to doubt that they would violate that oath at this time. So I took and I made the decision to withhold telling the parties because we were in the middle of instructing the jury. I was in the middle of instructing the jury, and I wasn't going to delay the proceedings because it was so speculative at that point and remains speculative at this point. As you know, the case went to the jury. I brought this up. I waited about a half an hour once the case went to the jury. Frankly, we had had a long day. I wanted to get a bit to eat, and then I wanted to come back out and make a record of what I had. Once again, the forensic unit with the Sheriff's Department has taken lead of this investigation. I'm not a part of that investigation. Law enforcement will handle it. From my perspective, not only did the Clerk of Court's office receive emails regarding this, it sounds like the District Attorney received emails. I may have even gotten one, I don't remember the time, it was later, regarding the post. Frankly, people figure out my email all the time. It was not solicited by me in any way, and I did not respond to it, and I simply forwarded that email on to law enforcement. So it's pretty clear to me that a lot of people have access to Reddit. I personally am not a user of Reddit, so I don't know the ins and outs of it, other than it is a social media site where people can create accounts and post, and there can be like chat rooms, for example, or just various, as this is called, subreddits. And at this point, you've requested a mistrial. You've requested that I discharge the jury. I'm declining to do that at this time, sir. Again, I need to make decisions based upon the record that's before me. And right now, the record is speculative. There are no facts to support a mistrial or discharging the jury. I trust the parties will continue in their own independent investigations, that you will continue reviewing case law, make whatever requests that you deem appropriate. I certainly will take time to look at the cases you have cited, to see if there's anything based upon the requests that you have made that I would need to further review. But at this time, I do not see grounds for a mistrial. I do not see grounds to discharge the jury. That is how I will address it at this point. I know the state, I believe, wanted to address something else. I'm not sure if that was it, but you had deferred to Mr. Brooks, so go ahead. Is there anything you want me to address or at least bring to the court's attention at this time?
Just a minor point, Your Honor. You had noted the defendant is in his orange jail uniform today. It's my understanding the jail did offer him the ability to put on his street clothes, and he declined, so I just wanted that on the record. There may be occasions where this jury has to be brought into the courtroom for one reason or another, and he should be in civilian clothes if that occurs, if he chooses to.
It's a good point to bring up. It is possible the jury would need to be brought out if there is any question that I need to answer on the record. If for some reason the technology were not to be working appropriately when videos or other evidence are displayed to them. And so it is possible that the jury would need to come out. Of course, they'll come out if and when a verdict is reached. So I would certainly give you the opportunity, sir, if you want to change into the street clothes, that I would certainly direct the Sheriff's Department to make that available for you, should you choose.
Isn't it my choice?
Yes, it is.
So why do I need to be in street clothes? Why does that need to be on the record? That
your choice should be placed on the record, sir.
If not, I was offered to be in street clothes if I made it the choice.
Do you dispute that, sir?
Yes, I dispute it because it's my choice.
Well, no.
You know, he ought to thank, although we all know, at least I feel like he detests Sue Opper. He ought to be damn lucky she's keeping such a good record. And again, she's doing this for the benefit of him, even though he doesn't think that. He's so paranoid. I guess because he does such hideous stuff to people, he expects the same, I suppose. But she's just trying to keep all the records straight. Nobody's forcing him. They're just trying to give him that opportunity, if he wants to, in case something comes up later. I think it's perfectly fine. But you know what? As my friend would say, do you, boo. Hope I got it back in the right place. I should have it close to it anyhow.
Dispute that you were given the choice this morning.
At this point, there's no reason why that should be on the record. That if I was not offered street clothes, what relevancy does that have to?
Could have potential relevancy later on if
Why?
you were to challenge that you and claim that you were required to wear your jail uniform or jail attire. You're
see
not
there?
required.
I
This
didn't
is
make that
trial.
request.
You have the right to wear
She didn't say
street
that.
clothes, and I will certainly provide that opportunity should you wish to change at any point in time. But what you're telling me is it's your choice to be in jail attire. I'll respect that choice, of course.
So why does that need to?
That's
be
good. She's already
stated in
accepted
the
it.
record?
I just
She already said it.
indicated why, sir. So
I don't see the
She
relevance.
sure did. She explained it. She explained the relevancy. So if something comes up later saying that you were forced to wear your jail clothes, go on and wear your ugly orange jail clothes. We don't care. They're just trying to keep their record straight.
Relevancy of it.
all right, at this
I
point,
never-
unless
Yeah,
there are
yeah,
any
just
further
you look at her,
issues,
she's
I am
just
going
like-
to go back into my office. The courtroom
I don't
will
blame
remain
her.
open, and we'll let you know when the jury communicates with us, either about a question or verdicts.
There is something that needs to be addressed. Subject matter jurisdiction.
Oh, for the
The court
love of God.
declines that, I'm stepping off.
Why hasn't it been proven on the record yet? And I object.
Blah, 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 blah. Oh my gosh. He's such a nut.
Versus Brooks appearances are as they were before. I would make just one note that Mr. Brooks is now present in a suit. And I will also advise that at 9:43 a.m. this morning, I was advised that the jury had reached verdicts in this matter.
Ooh.
And without anything further, I'll have the jury brought out.
Your Honor, I don't consent to being called that name. I'd like to address subject matter jurisdiction for the record. I have yet to be
No. You're done.
Objections are noted.
Isn't it interesting, though, that he decided to put on a suit after all? Huh? I wonder if he started thinking about, who knows what goes on in his mind. Most of us don't think like him, so we couldn't possibly know. But, you know, he's still trying to, with this stupid subject matter jurisdiction, his last-ditch effort to delay. The time has come. It's time. It's time. It's time.
I will not be addressing subject matter jurisdiction. Please bring the jury out.
Would it be proven for the record, Your Honor?
Dude, they're coming out to give your verdict. You need to shut up. I'm sorry, I shook the table a little bit I mean, most people are very quiet during this, but we're dealing with Darrell. Wonder if he's going to take his
Just
mask
a
off.
reminder to everyone that I do expect everyone in the courtroom to demonstrate appropriate decorum and courtesy as the verdicts are read and refrain from audible responses. Any disruptions may result in removal from the courtroom.
Your Honor, is that a tacit agreement not to address subject matter jurisdiction for the record?
It's so
Jury's coming in. All
Stupid.
rise, please.
I respectfully object to that ruling, Your Honor, and request the legal reconsideration of your ruling.
they're coming in, man. They're coming in to give you your damn verdict. Don't do all of this. It's time. You're making a fool of yourself. He doesn't care though. He's been a fool the whole time. Okay.
For the record.
Your requests are noted, sir. I will not be addressing that further.
For the record, may I respectfully reject that ruling and take exception to that ruling, Your Honor?
No.
Is that a tacit agreement and a judicial determination that you don't have to answer that question as a public servant, Your Honor? For the record, may I request the legal or factual basis for your ruling, Your Honor?
I love it. She's just ignoring him now. Good for her.
It might have been a false alarm.
For the record, may I respectfully request a written judicial finding of fact and conclusion of law on this issue, Your Honor?
You're not going to
All your
stop.
requests are noted for the record. They all are denied, sir. All rise. Jury's coming in.
For the record, may I respectfully move for an interlocutory declaratory appeal?
Is he really going to do this as they're coming in?
Denied.
For the record, may I move to stay these proceedings until
My
this
God,
instant matter
he
is
still
adjudicated
annoys the
by
hell
a
out of me.
competent jurisdiction.
Denied.
Based on what law or fact, Your Honor? Is that a tacit agreement that you don't have to answer that question? For the record, Your Honor, as a public servant. You don't have to address admiralty law or common law if this court is operating under admiralty law.
I will not be addressing any of those issues. Thank you,
Respectfully
everyone.
object,
Please
Your
be
Honor.
seated.
Sit down. Shut up.
Ladies and gentlemen of the jury, have you picked one among you to be the foreperson? All right, and I see it's juror number 11. Have you reached verdicts on all 76 counts?
Yes.
All right, would you please hand all of the forms to the bailiff?
That's a lot of forms to go through. Is he really? He's not gonna say anything, is he? Looks like he's gonna say something. Please don't say
Your
anything.
Honor, seeing is that we've reached a verdict, is it necessary that I have these shock devices on my ankles?
Oh, you know what? And we already know about the shock device. He's come back with that. There were no shock devices. Although, again and again, as I've said, and I think y'all have agreed, that none of us would have any problem if he did have shock devices. Trying to get pity. The verdict's already in, so it's you're just ridiculous, Darrell. I can't. What that jury had to go through, and everybody in the courtroom, the victims having to listen. At least I can turn him off and walk away. We can turn him off and walk away. But they had to sit there and be captive by his idiocy. Shock devices, please. We can only dream. Wouldn't y'all love to know what he's thinking? Do you think he really thought he was going to get a not guilty plea or sentence, whatever? Verdict, I should say. Amongst this, I never want to forget about the families, and all the people that were injured, and the victims' families. Some people, probably many, have lifelong injuries due to his impulsive, angry tirade. This is about justice for the people of Waukesha.
And I have confirmed that there are 76 signed verdicts and 76 unsigned verdicts. Which would be what I would expect. All right, I will read each one into the record. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information, dated this 26th day of October 2022, signed by the foreperson, juror number 11. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes.
Or in hell, you piece of shit.
Hey, you are to be removed right now. You will not do that.
Please hold.
We, the jury, find the defendant, Darrell E. Brooks, guilty of
I don't
first-degree
blame them,
intentional
though.
homicide as charged in count 3 of the information. And I should state as to count 2, it was signed and dated by the foreperson, same as to count 3. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 4 of the information, dated this 26th day of October 2022, signed by the foreperson. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 5 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 6 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 7 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 8 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 9 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 10 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 11 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 12 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 13 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 14 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 15 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 16 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant guilty of first degree recklessly endangering safety as charged in count 17 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 18 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 19 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 20 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 21 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 22 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 23 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 24 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 25 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 26 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 27 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 28 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 29 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 30 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 31 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 32 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 33 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 34 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 35 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 36 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 37 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 38 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 39 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 40 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 41 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 42 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 43 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 44 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 45 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 46 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 47 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 48 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 49 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 50 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 51 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 52 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 53 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 54 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 55 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 56 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 57 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 58 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 59 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 60 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 61 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 62 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 63 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 64 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 65 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 66 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 67 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 68 of the information. Did the accident involve death to Virginia Sorensen? Answer, yes. Dated today's date and signed by the foreperson. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 69 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Leanna Owen? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 70 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Tamara Durand? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 71 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Jane Kulik? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 72 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Wilhelm Hospital? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 73 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Jackson Sparks? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of bail jumping as charged in count 74 of the information, dated today's date and signed by the foreperson. We, the jury, find the defendant, Darrell E. Brooks, guilty of bail jumping as charged in count 75 of the information, dated today's date and signed by the foreperson. We, the jury, find the defendant, Darrell E. Brooks, guilty of battery as charged in count 76 of the information, dated today's date and signed by the foreperson. Mr. Brooks, would you like me to poll the jury?
Yes.
Members of the jury, I'm going to ask each one of you individually to stand up, identify your number for the record, and then state whether the verdicts read in open court are your true verdicts. I'll start with the foreperson. And I'll read your numbers first so it's a little bit easier. So juror number 11. Were the verdicts read in open court, or are the verdicts, let me rephrase that. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 3. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 6. The verdicts read in open court, are those your true verdicts?
It is.
Thank you. Juror number 14. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 19. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 27. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 34. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 41. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 45. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 46. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 48. The verdicts read in open court, are those your true verdicts?
They are, Your Honor.
Thank you. Juror number 51. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. I should state for the record, I did have the alternates brought back in. Obviously, they did not deliberate, but it was important to have them because there are certain instructions I give at the end. All right, Mr. Brooks, are you satisfied with the polling of the jurors?
No.
I'm sorry?
No.
The court is still satisfied with the polling of the jurors.
Isn't that something to go on and say no? Of course he's not satisfied. I guess he answered honestly, but, come on, what did he expect? And boy, they answered very strongly with their answer. Nobody stuttered. What do you expect? And yeah, I know I'm sorry that I had to look at those fingernails through all the reading of that, but hey, it is what it is, right?
The court now accepts the verdicts. Ladies and gentlemen, on behalf of myself, the citizens of Waukesha County, and both parties here, I want to thank you for the time and attention that you've spent on this case. Your service in this case is now concluded. There's no requirement that you maintain secrecy concerning what happened in the jury room, but you do not have to discuss the case with anyone or answer any questions about it. On behalf, again, of the court and all of the parties, we thank you for your service over the last 3.5 weeks. You are discharged and free to go. All rise for the jury, please.
Well done, jury. You put them through hell, Darrell. Making them go back and forth. No.
Thank you. Be seated. Anything from the state at this time?
Your Honor, the state moves for judgment on the verdict as to each and every count.
Anything from you, Mr. Brooks?
What is judgment?
Given the verdicts from the jury here today, the court will enter judgments of conviction based upon the verdicts on all 76 counts. The court will also revoke bond. In this case, I plan on bringing the case in Monday this coming Monday, the 31st at 1 p.m. to address further scheduling. What I would ask the parties to do between now and then is to determine how long you think each side will need to present their sentencing remarks, whether you anticipate anyone speaking on your behalf. If so, how many, how long, so that I can then look at my calendar and adjust and make sure that I have the appropriate amount of time to do that. I'm not going to sentencing on Monday. It is just for further scheduling at 1 p.m. before my afternoon case.
Judge, would you be willing to consider persons appearing by Zoom for sentencing?
Yes, I would not do anything different than what I've been doing since we started utilizing Zoom, and that is to make it available for both victims and family members of the defendant if they so choose to make statements over Zoom.
Okay, thank you. That
You're welcome.
helps us in our planning.
All right. All right then. Thank you, everyone. We are adjourned for today. We'll see you all on Monday.
Okay, I think that the attorneys are going to speak. Well, I don't think Darrell gets to speak, but the prosecution. So, well.
You want to tell Carrie to come down here? Dave, will you come down? I know. It's gotta wait for some of the family members.
Brandon, I thought you said one camera.
I know, that's, I'm just already giving you grief, and like, your idea of one is.
Brandon said one camera, one microphone. Somebody didn't bring their recording equipment. We're not gonna say who it was.
Thanks for busting them out though, Leland, I sure appreciate that.
We can scooch.
Yeah, make sure Pepper gets the FaceTime, please.
Well, yeah. You know, Pepper was the support dog for the victims, the survivors.
You're not live, Brandon, right? Okay, thank you. Very good. So there was another family member. I'll spell her name so you guys don't have to take the picture. Amber Konke, Afber, Kohhnke. She's the mother of one of the juvenile victims. She'll also be speaking. I'll start from the beginning. Kohhnke. So everybody else, the previous four. So thanks, Jim. The previous four are still going. Sue Hopper, Chief Thompson, David Sorson. And then we'll take a few questions after that. And I'll do introductions as soon as the family members come down here.
You're gonna moderate the questions? Okay, thank you.
One, all.
Yeah. Do you want me to run up there? No. Do you want me to run upstairs and? For Carrie, I didn't bring my phone. Ryan.
Oh, good. You guys are all staying together. Perfect. Where's the four? Oh, perfect. You guys set this up perfect. Ryan, we'll go right you four right away. And then, come on, Pepper. You guys set this up perfect.
Yes.
Gold stars for everyone.
Yeah, let's, because these camera guys come on in over here. And then if you want to walk around, go by Brad right there, Brecky right there. Just kind of filling over there.
Thanks for coming in. Thanks.
And then you two go behind Brian right there.
Hey, Dave.
David, Brian, grab him too.
family members.
Who's right?
I'm sorry.
All right, and then for the Swansons, maybe you guys move in a little bit. Okay, you guys look at that big screen. You can't see our space up there. So Tyler, can you move in a little
I
bit?
think I'm consenting now. What's the point? Because Warren and I continue standing here. We did.
Swanson?
Yeah. Come on over here.
Pepper tap on my shoulders.
Pepper, the support dog, is the
All right, I'll go on
star.
you whenever you're ready.
What a sweet looking puppy.
All right, thank you. Good afternoon, everyone. We're here to have a press conference to discuss some of the events that happened today. Speaking today will be District Attorney Sue Opper, Chief Dan Thompson of the Waukesha Police Department, also David Sorensen, which is the husband of Virginia Ginny Sorensen, Tyler Pudliner, he's a Waukesha South band member, and Amber Conkey, a mother of one of the juvenile victims. Also present with us today is County Executive Paul Farrell, the prosecution team consisting of Leslie Basie, Zach Witchow, Detective Tom Casey from the Waukesha Police Department, Detective Ryan Rugland from the Waukesha Sheriff's Office, and paralegal Christy Giese. Also to my right, your left, is Jen Dunn and Carrie Peterson from the Waukesha County District Attorney Victim Witness, and with our comfort dog Pepper, who have played an integral role with our crime victims throughout this whole process. To that, Sue Opper.
Thank you. First and foremost, our thoughts and concerns remain with the victims involved in this tragedy and their families. Although the defendant devastated our community, the people of the city of Waukesha, Waukesha County, and beyond demonstrated tremendous resiliency. We are so grateful for the first responders, citizens, and medical professionals who sprang into action and immediately rendered aid and saved so many lives that day. We appreciate the jury for their work and dedication to justice. We commend the police officers and citizen witnesses who testified or were prepared to testify and asked to relive the events of that horrific day. We are satisfied that this defendant has been held accountable for his actions. He now faces imprisonment of 6 consecutive life sentences plus 859 years of confinement. There is much healing ahead for the victims and for our community, but we hope today's result is a step further along that path. Remain strong, Waukesha. Thank you.
Waukesha Police Chief Dan Thompson.
Thank you. 2 days we'll never forget. November 21 of 2021, on that tragic day, and October 26th of 2022. Why October 26th? Because justice was served today. I want to say thank you and praises to this community. I want to say thank you in the resiliency and strength of the families and victims who are involved in it and were impacted by this event. The investigation team, I want to send a personal thank you to the District Attorney's Office, Sue Opper, Leslie, Zach, and everyone on that team who assisted in this successful prosecution. I want to say thank you to the jury and the court process and the court proceedings and everyone that's involved in the court who found this defendant guilty, which is just and right. That defendant's actions did not define this great community. They refined us in our resolve and our strength in being Waukesha strong. Thank you.
David.
I had not seen this before. It's very nice. Oh, this is Virginia Sorensen's husband, and I think her 2 sons.
Thank you. I'm David Sorensen.
Oh, bless
These are my
him.
2 sons. Justice was served for my wife, Virginia Sorensen, my 3 children, and the whole Sorensen clan. Thank you very much to the people that did this court case. We appreciate it. Sean or Marshall wants to say one little thing.
We've been praying for this day for a long time, and this morning my 5-year-old daughter came up to me and handed me this necklace with my mom's ashes in it, and she told me to take my mom with us for the sentencing. So she was with us today, and
Oh my gosh.
I just want to thank everyone for what they did today. And one last thing, my mom always used to tell us when we were kids in our family that she always said, angels watch over you guys. So I just want to say, angels watch over you guys, and turn on those blue lights tonight. Thank you.
Oh my goodness. Oh man, this is a tearjerker.
I want to first thank the prosecution team. They were the one that got us to this point. I'm thankful for all their support along the way and getting us to this day. It's been a difficult day. I know that this will give us healing. This is another step forward in this process. We've been resilient all the way through. One of the things that I've said so much throughout this is that we're stronger than him, and it's been proven today. It's just another step forward in the process. So I want to thank Sue, Zach, Leslie, all those guys for their hard work, Jen and her staff, and especially those first responders. It's been brought up. They are the ones that especially kept me here, gave us a second chance, and they've kept our community strong. So yeah, walk us strong, as Marshall said he touched on, and keep those blue lights on tonight. Thank you, everybody.
Just want to say that I'm very happy with the verdicts, and that justice has been served today. I would just like to thank everybody, the first responders, the DA, and the judge, all the law enforcement, everybody who was involved, especially those who were very much involved with my family and the support system that we have had. It's been amazing to see how wonderful this community has been to pull together for all of those who were hurt that night.
With that, we'll take a few questions. Those available for questions will be Chief Thompson and District Attorney Sue Opper. So I'll start right here, TMJ4. Who would you like to direct your question to? Sue, come on up.
Okay.
Chief.
Just gotta know, how are you and your team feeling right now about this outcome?
Well, it's obviously quite satisfying that Mr. Brooks has been found guilty and held accountable for his actions. As many of these victims have said, this is a joyous day for that reason. It's also the point where we hope everyone can move on from. The support that we've gotten as this case wore on day after day was tremendous, and we're very relieved. I guess that's the best word, is relief.
Hillary?
I saw you had a tear in your eye when they were talking about Virginia's ashes. You spoke about what this meant to you and victims. How do you begin to describe what it was like going up against Brooks, defending him, representing himself? Did that change your strategy? How did you get through all that?
Yeah. I mean, legally it changed our strategy, certainly, because if there's an appeal, we have to do, he can make a mistake in the courtroom and get a new trial, and we have to pay the price for that, we the state and we the victims. So it changed our strategy in that we had to make sure, and Judge Darrell did as well, the record was very thorough, very complete, and we didn't miss anything. But as far as handling the actual court proceedings, we felt very, very offended by his behavior, his disrespect of the court, the
Excuse me,
decorum,
guys.
the families. his insulting the judge, his challenging the judge. That's not the way our system is designed. That was intentional on his part. We truly believe that. He did everything he can except claim that the dog ate his homework. And he
amen.
tried to turn this into his story. Let's talk about Mr. Brooks and his family. And we just kept redirecting it back to the real focus here is our families, our victims, our community, and his responsibility for this destruction.
58.
What was the most challenging part, and how did you keep your patience through?
Again, it wasn't a difficult case factually, and I don't mean to sound, overly confident in that, but this case was unique because the activity was videotaped, right? And so, whereas most cases we have to rely on eyewitness accounts or other ways to prove the case, we had videograph evidence of his behavior all up and down that crime scene and throughout the neighborhood. So that way, it wasn't difficult. Again, the difficulty and the challenges we faced was what nonsense was going to come out of his mouth next. And we were anticipating much of what would come next and being ready legally with case law and legal authority to be able to respond to that. So I think that was the hardest thing. The investigation was so thorough, so well done that we knew the facts were solid. It was just making sure the record and the presentation was done legally accurate.
We'll do Fox Local.
So what went into your decision to perhaps minimize the number of direct witnesses that went up on that stand? And I wonder if you expect any of these antics if that went into your decision.
Yes, it did. So obviously we didn't know until very late that he'd be representing himself. But we as a team set out from day one, and this was months and months ago when he still had attorneys, we vowed we would not put children on the stand. Absolutely. It wasn't necessary. Again, there were plenty of other ways to tell this story without asking a child to testify in a courtroom and relive this very, very extreme tragic situation. So that was a commitment we made as a team months ago, and we stuck by that. Certainly, as we learned his antics, we reevaluated, and we would discuss it every night as a team: is who are we going to use tomorrow, and do we really need this person? Because we were so, again, not personally offended, but professionally offended that he would insult the process and insult the victims, accuse them of financial gain for their testimony, things like that. It was just so offensive that we definitely were conscious of that in our decision making and how can we minimize this for the best of everyone, but still provide a compelling story. So yes, it did definitely play a factor.
Court TV.
Thank you so much. Ms. Hopper, there were so many victims' families inside the home every day sitting behind you. How much did that motivate you and your team and how you present your evidence, your closing argument? You mentioned them, and have you been able to speak to any of them that aren't here that maybe said something to you afterwards?
Yes. The motivation we received from those families was tremendous. And we knew, again, from the point when Mr. Brooks chose to represent himself, this was going to be a marathon. We talked about that many times as a team, that we just need to keep moving forward every day, whatever that looked like. But what motivated us was these families that are behind me, a lot of them. And we thought of those mothers and fathers sitting in hospital rooms with their children and the ongoing care that they're still physically healing from and certainly emotionally healing from. And that motivated us tremendously. But you couldn't meet a nicer group of people. I mean, that's the thing, is I'm not surprised, having lived in Waukesha for 35 years, that they're good people here. And they would ask us, how are you doing? Do you guys need anything? Which was really phenomenal. They were a tremendous group of people to work for, and it was our honor to represent them and be a voice for them in the court.
Yesterday seemed to throw Darrell Brooks a little bit of a lifeline when it came to presenting his closing argument.
That was strategic for the appeal, to be very blunt. I wasn't throwing a lifeline to Mr. Brooks. I really had no interest in hearing what he had to say because I heard all of his lies and stories so far. So that was just trying to do what was legally required at the moment. And I frankly wasn't sure it was going to work because he was so difficult with Judge Darrell. But in the end, it did work. He got to blurt out what he wanted to blurt, and then the judge struck that from the record, and we were able to move on. So I was glad that that was the result, but we talked about it at the prosecution table and came up with that idea of let's offer this, again, just to protect the record for the appeal.
Jim.
Again, his absolute disrespect and dishonor to the victims, the community, and the court process.
I'll do Brian from the Freeman, and then two more we'll do CBS, and then where are you from? Okay, those are the last three. So go, Brian. You got one.
There has been some discussion since the verdict was announced that perhaps the decision to represent himself is grounds for appeal. Are you concerned at all about that?
Well, Mr. Brooks has a right to an appeal. Every defendant does. And I fully expect him to take advantage of his rights as a convicted defendant in this case. I am very confident in the record that Judge Darrell made and his decision to represent himself. Yes.
Go ahead.
Hi, I'm Roxanne, CBS News. What do you think about the length of time that the jury took to deliberate? Short, long, surprised?
We were not. We talked about it last night, and frankly, I know a lot of you were here too. We were all, by the time we got to that 8 o'clock mark, we were exhausted. And when they said they wanted to go home and rest, we were thankful, quite frankly, because we all felt the same way. It's such an emotionally draining day. And to get through all that and the nonstop banter from Mr. Brooks, it's taxing. You all witnessed it yourself. So we were grateful. We thought they gave it good thought because they went out around 6:30. Their dinner was there immediately, right? So jurors are human beings. They get a nice meal. They got a little time to talk, and then they decided, let's rest. Let's sleep on it. Always a good option for decision making for anybody, right? Get a good night's sleep on it, and come back the next day. And then, they worked again for about another hour this morning, and with the quality of the investigation in this case, we think the verdict was fair. The timing was spot on.
Go ahead.
There's a lot of people who are here today, of course, and a lot of people who are also praying on the day of the parade who aren't here. In closing, what do you want to say to them at the end of this process?
Well, I hope some of you caught the flavor of that. You cannot imagine until you saw some of those videos how horrific it would have been to stand there and watch that. Especially when your children, and some of these witnesses testified to that, they couldn't find their children, right? And that's not just people who were struck. That there was many citizens who could not find their own child for a period of time. So just unbelievable. But once the car went through and everybody had that initial, the way citizens of this community punched in. There's no other word for it. The nurses, the doctors, the EMTs, the paramedics, anybody who knew anything about how to apply a Band-Aid walked into that street and treated those people. So that was another source of strength for us, right? Is if they could do that, we can get through this.
As we move on to the next phases of the judicial process, I'm sure that people will be readily available to provide comment as we get into. We have a court hearing on Monday at 1 o'clock, I believe, for scheduling, and I think then we're going to go into the sentencing phase, and we'll know more about that. People here behind me will make themselves available for you, I'm pretty much sure, as this goes on. But as of right now, we're going to end it and allow people to be with their families. And definitely, this prosecution team needs some much-needed rest and some time away from this courthouse. So thank you all very much for being here today.
Thank you,
guys. If we could make a line so I can allow these people, thank you. It was more so at your camera.
It was really great to be able to hear from everyone. There's the star, Pepper. Yep. Emotional support dog. I think that's what they call it. Anyhow. Dogs are wonderful. I've heard it said before, we don't deserve them, and that's about true. But wow, even though we know it's happened, some time has passed, but still, to see this and see the families, it does seem like an amazing community. Oh, that sweet puppy. I wonder if Pepper's still there. I believe I read somewhere that Pepper is still there and is kind of like part of the community now. I mean, probably, I'm not sure if Pepper's a he or a she, but whichever. You know, probably still a great comfort to those victims. You know, really and truly. But there's that. That was, yep. They laid out. Everybody was aware of his shenanigans, and he just thought he was so much smarter than everyone else, and I'm glad that they proved that he, in fact, was not. So with that, this has been a long one. We will go, the next one will be the next phase. I don't know if I know they're going to have some discussion about the sentencing and then the sentencing. I mean, if he's going to be there, it's probably worth recording. I might be able to get that and the, pretty soon we'll be coming up to the end here with the victim impact statements. Excuse me. But once that is done, we won't be done with Darrell because there's still so many things we can pick out from the court process to talk about, trust me. So, this doesn't end Darrell until we're all ready for it to happen. But of course, there's still other cases too. And so with that, I want to thank you all so much for watching, liking, subscribing, commenting. This is like, it's kind of an emotional roller coaster, even though, I wasn't even, we weren't present there. At least I can't speak for you all. Maybe some of y'all are, I doubt it. But anyhow, it's just like we're going through this process with them, at least the court process. And it's, man, what he put those people through, but I'm sure that his life is not happy. It's not a great life. So, justice was indeed served. And with that, I love you all so much. Again, I appreciate you. Be kind to one another. Be kind to you. And I'll see you the next time.